is Edmund Paul Zambrano, and we're looking for Miss Allison Perry and Miss Jennifer DeVries. Good, I guess now it's good afternoon, Miss DeVries, and let me see Miss Allison Perry. I see her name. She just needs to take herself off of mute. Miss Perry, can you hear me, ma'am?
I can hear you.
Great. And I don't know if you're appearing by video. If you are, your video is off and you're welcome to proceed.
Audrey, can you fix my video? I have a child that can probably fix this.
All right, ma'am.
I don't know why my video is not showing up.
No problem. No problem.
You don't have to see me though.
It's entirely up to you, Miss Perry. We've proceeded with oral arguments with and without, so it's really up to your pleasure.
Well, I don't want to delay it. I just had my computer work. Oh, wait a minute. I think there we go.
There we go. Now I could see you. All right, Miss Perry. All right, Mr. V. So we'll go ahead and proceed. As you know, each side is provided with 20 minutes. And Miss Perry, how much time do you need for rebuttal, ma'am? And
I would like 5 minutes for rebuttal. Your Honor. Good afternoon, Your Honors. May it please the court. Yes. My name is Allison Perry, and I, along with Dale Klaus, represent the appellant, the former wife, Dr. Maria Valdez. And I'd like to reserve 5 minutes for rebuttal. The former wife appeals the 50-50 rotating custody arrangement from her final judgment of dissolution of marriage. This was at a time when her triplets, the party's triplets, was 3 years old at the time of the dissolution of marriage. The wife appeals it on 3 grounds. She also appeals the ultimate decision-making authority on the children's extracurricular activities. First, I'd like to address the rotating custody arrangement. The court legally erred on 3 different grounds. First, the court believed that there was a presumption in favor of rotating custody under 61.13 when no such presumption exists.
Help me out with that, Miss Perry, because I know this is what you're referring to, but in looking at what the judge said, I didn't get that impression. I think it just lead me to where you think that she actually was under the impression.
Well, on page 294 through 95 of the transcript,
yes,
where the judge said, except the law promotes 50-50 child sharing. So unless you're an axe murderer, that's what you get. So unless you're an axe murderer, you get 50-50 time sharing. That's pretty clear that the judge believes that 50-50 is what Florida promotes.
And
Ms. Perry,
oh, go ahead, Judge Laros.
Apart from a flippant comment, that comment is inconsistent with the amount of time she spent detailing each of the relevant factors under the statute.
The factors are there to go through so you can weigh to determine what is in the children's best interest. And when you go through the factors, most of the majority of the factors, and the court found that over 50% of the factors weigh in favor of the mother. That was a specific finding of the court. And
but she was careful to, this is not just a quantitative analysis, it's qualitative as well, is it not?
Yes, it is. But the factors, all the important factors, cooperative, the cooperation, the items that the father that weighed in favor of the mother offered stability to the children, the father was calling the police on the mother when the mother wanted to feed the children chicken. The father called the cops on the mother when she would not let the children go to a baby shower in Miami. This court in the Grisby case has found that a parent that uses the police to use to promote false domestic violence claims against a parent, to try to promote themselves in custody disputes, that is grounds alone to not let them have it used to be primary custody of a child. That to interfere with the custodial rights, because doing something like that shows the disposition of a parent to not act in the child's best interest. And again, the first judge that was on this case and the second judge repeatedly said that the husband was not acting in the child's best interest. The way that the father lied repeatedly, lied to the cops, lied to the custody evaluator, lied about his past, wasn't trying to get a job. It told the judge in the temporary hearing that, oh, I don't want to work because I want to take care of these children full time. And then when the judge gave him the children full time, the children ended up in daycare full time because he couldn't handle them. Time and time again, this father demonstrated issues that point to a severe personality disorder. Yet the custody evaluator did not conduct psychological testing, which is why Dr. Day was called in. That was one of the other errors that the trial court committed, because under 12.364G, Dr. Day is allowed, or a custody evaluator that's qualified, like Dr. Day, of course, is allowed to look at the custody of the court-appointed custody evaluator's file to determine if the custody evaluator did a standard of care correctly. That if
as I understood, Ms. Perry, the ruling on that more had to do with the concern that one side was calling an expert to basically poke holes in the other expert's testimony, which ordinarily you don't get to do.
But you do under 12. That's exactly.
That's not how I read that rule, Ms. Perry. They have access to it, but it doesn't mean that you get rid of the rules of evidence, and that you can call someone just to, one expert just to point, fly spec and point all the things that another expert testified to incorrectly. You get access to the materials, but you don't get to suspend the rules of evidence. It was how I understood the trial court's ruling on that.
Well, in this case, Dr. Day pointed out that there were many red flags pointing that a psychological testing should have been done on the husband because of all the. Was
it pled for?
Yes, it was.
Psychological testing?
Psychological. It was requested by the wife.
Where and when? When was psychological?
It was done in the
petition. Was it in the initial petition?
I don't know
or
if
the
it's
answer?
in the petition, but it's the wife definitely requested it because it was at issue, and it was something the wife wanted done because it was a concern to her, especially, and we've got triplets here. I mean, we've got toddler triplets. And we've got a man who carries guns around with him, keeps them loaded, sleeps under his pillow.
Ms. Perry, as I understand the record, calling the cops was remote in time. The guns had been disposed of. And I'm correct in that, am I not? He had gotten rid of the guns.
Yes, he had gotten rid of the guns.
Okay, so,
okay.
Well, it's ancient history.
Okay. Well, the another error that the court committed, which the court did not find that it's in the children's best interest that this rotating custody arrangement was in place, and that is required. Now, this court, I quoted Decker v. Lyle, which quotes a lot of second DCA cases, but it's required even in a temporary custody arrangement that either in the record or somewhere in the final judgment, it is required that the court find that it's in the children's best interest. It was clear in this final judgment that this 50-50 custodial relationship, time-sharing schedule was made in order not to punish a father. It wasn't examined to see if it was in the children's best interest. It was made, frankly, just because the court didn't want to punish a father for his lying and other misdeeds, did not examine what was in the children's best interest. There's no examination. It's not said. And if this court is going to follow its own law, it has to reverse, because there's nowhere. And if you look at the answer brief that the husband filed, the former husband filed, no less than 15 times, they state in there that the court appointed expert and that the judge said that this time sharing arrangement was in the children's best interest. And that is not the case. Nowhere in the transcript, nowhere in the final judgment does the court say this arrangement is in the best interest. Nowhere does the custody evaluator say this is going to be in the children's best interest, that they have this 2-2-3 time sharing schedule, this rotating time sharing schedule where they go back and forth and they spend 50% of their time with each parent. It's completely absent. And that is fatal to this time sharing schedule. You have to follow the precedent that requires the best interest of the children to be considered. Now,
along those lines, because I pulled it up, I thought the court did take that into account. Didn't she, at the conclusion of her recitation of finding, basically said, when she was agreeing with one of the experts, I believe she said, what is it? So with regard to the decision making, making a finding that the ultimate decision would not only be in the best interest of the children, but would be detrimental to the children if I do whatever. So it's quite clear that the court, it was implicit in everything that she's done, that she was taking into account the children's best interest. Am I missing something?
Yes, because that's separate from the time sharing arrangement. That had to do with decision-making authority over educational decisions, religious decisions, school decisions. That was best interest. That decision that's under 61.13 2C2A, that a court can give ultimate decision-making authority to a parent if they find that it's in the children's best interest, that a parent have ultimate decision-making authority. They do not, you know how shared parental authority, decision-making authority is promoted?
No, and I understand what you're saying, but that whole theme has been throughout. When you look at the judge's comments, when you look at the final judgment, it's almost implicit in that she was taking into account the children's best interest in arriving at her conclusion.
But that ultimate decision-making authority has nothing to do with time sharing decisions.
No, and I see
what sharing is.
No, I see what you're saying, Ms. Fair, but I'm going back to when if you look at the final judgment itself, the way that she laid out everything, as I read her findings, it makes it clear to me that it is implicit in her rulings that she did take into account what would be in the best interest of the children, and also recognizing what the requirements are in the statute to allow the father to be able to, to be given as well. So that's what I'm arriving at.
Okay. The purpose of going through these 20 factors is to determine, okay, there is a case that I cite in the brief that it's called Newman v. Harper, and it's at 106 Southern 3rd 974. And this quote is at page 976. And it says, in crafting a parenting plan in the best interest of a child, the trial court considered and weighed the factors set forth. The majority of factors considered by the trial court in determining a proper time sharing schedule weighed in favor of the father. So therefore, when the factors weigh in favor of a parent, that's what tells the court what's in the best interest of the child. That's the purpose of going through all the factors. You don't just go through the factors and every factor was either neutral or weighed in favor of the mother except one. And that one factor that weighed in favor of the father had now become moot because the children were in daycare now. So that one factor that weighed in favor of him really had become moot. But the whole purpose is when they weigh in favor, that shows you, that tells the court what's in the best interest. But here, the court had the presumption that it was 50-50. I mean, if a court believes that you're going to get 50-50 unless you're an axe murderer, I do not know how much more clear you're going to get 50-50 unless you're an axe murderer.
Ms. Perry, could it be that the trial court might have just been talking aloud and I think this is the law. I mean, I recall this as a trial judge, sometimes floating ideas or saying things, but hey, I think the law is this, but I'm not sure. And without having actually ruled. And then once hearing the arguments of capable lawyers who bring forth you realize, oh, wait, I was mistaken. The law is actually this. And then you reflect that in your ruling. You seem to be saying that because she made this verbal statement, it must have been baked into her final ruling, even though she didn't say that in the final ruling.
But then she's got a final ruling that shows all these factors weigh in favor of the mother having the final judgment clearly shows the judge's findings and the court-appointed experts' findings show.
Are the factors weighted equally? I mean, is it really just you tally up 12 in one, 8 in the other, and got to go with the 12? Or could it be that some factors, you might have a whole bunch in favor of one parent, but one really important one is in favor of this other parent? I mean,
some clearly are more important than others, but
yeah.
The ones that weighed in favor of the mother are the important ones.
Gotcha.
And if Ms. Perry, you're about to go into your rebuttal. Actually, you did, but I give you whatever you should do.
Regarding the decision-making, the ultimate decision-making authority of the extracurricular, the court failed to find that it was in the children's best interest, and that was clear. The court did find it was in the best interest for the mother to have ultimate decision-making authority, did not find that it was in the children's best interest for the father to have ultimate decision-making authority on the extracurricular activities. And in fact, the court-appointed expert said it would be in the best interest that the mother had this decision-making authority because of the father's angry outburst, how he controlled the mother, and that it would just basically be very not in the children's best interest. So that needs to be reversed. Okay, I'll say the rest for my rebuttal.
Very good. Thank you, ma'am. All right. Mr. Reese?
Good afternoon, Your Honors. May it please the court, Jennifer DeVries with Long & Associates down here in Naples.
And
I am representing.
Mr. Reese, I'm going to ask Ms. Perry, would you mind muting your microphone so that way we don't have any. Perfect. Thank you, ma'am. All right, Mr. Reese, sorry. You may proceed.
No problem. I am representing the appellee, Edmund Paul Zambrano, who is the husband in this matter. I was also the trial counsel in this matter. I'm going to stand by my brief. I'll just kind of go through a few points. I kind of broke my brief down into 6 points, which address the issue and then address some of the issues that Attorney Perry brought up. First of all, just a general point, the correct standard of review in this matter is abuse of discretion. It's not a de novo standard. The trial court did not err as a matter of law. There's no misinterpretation or misapplication of the law here. There was clearly substantial competent evidence to support the trial court's ruling and therefore must be affirmed. An appellate court will not disturb the trial court's custody decision unless there is no substantial competent evidence to support the decision. As this court was well aware, the trial court is in the best position to weigh the evidence and determine the credibility of the witnesses, and it's not for this court to reweigh the evidence or substitute its judgment for that of the trial court. And that's from the Sinclair case. Sinclair found at 804 Southern 2nd, 589, second DCA case of 2002. The trial court correctly analyzed and applied factors A through T of the Florida statute 61.13.3 to rule that an equal time parenting schedule was in the best interest of the children. The trial court, as you already said, the trial court did a thorough analysis of every single factor under 61.13, and she crafted comprehensive findings for each factor. At the end of the 4-day trial in this matter, the trial judge did make an oral ruling for this case. It turned out to be a 69-page oral ruling. And at least 23 pages of the 69-page oral ruling was dedicated to the factors, to findings on the factors. Now, there were other pages obviously dedicated to parenting issues, but specifically 23 pages of her oral ruling were dedicated to the findings of the factors. She begins the discussion by acknowledging the factors I'm required to look at pursuant to 6113. She ends her 23-page analysis saying, so those are my findings that are required pursuant to the statute. The trial judge also adopted Dr. Hanson-Cohen's finding as well. So there's actually 2 sets of findings within the final judgment of this matter. Excuse me. Pages within the final judgment, pages 2 to 11 of the 21-page final judgment are solely dedicated to findings of factors, the best interest factors pursuant to the statute. Appellant's entire argument hinges on a couple of comments. The first comment made by the trial judge, as you heard, the wife in this matter hired Dr. Day to basically as a review from the stipulated parenting evaluators report, which recommend Dr. Hanson-Cohen, which Dr. Hanson-Cohen ultimately recommended equal parenting time, a 2-2-3 schedule that was ultimately granted. While the wife's hired expert was on the stand, she was advocating that the husband should have been subjected to the MMPI, which is a personality test, to basically see if he had the capacity to parent. And I just want to make a quick comment. There was no request in this matter for psychological testing at all. Nowhere in the pleadings, nowhere in a separate motion did the wife ever require any psychological testing or mental health testing of the husband. But as the wife's expert was on the stand and was talking about the husband should have been subjected to the MMPI, some psychological testing, the trial judge, in response to the wife's witness testimony that husband should have been subjected to psychological testing, the trial judge responded, except the law promotes the 50-50 sharing. So unless you're an axe murderer, that's what you get. So all these subtleties are very helpful if we were all providing therapy to everybody, but it's really not that helpful to the court. The trial judge in this matter was merely responding to the wife's witness, whether a personality test would have been helpful to this court. Was it a wise decision for her to make a flippant comment and to comment on the testimony of the wife's expert? I don't know, but at most it would be harmless error. Clearly that's not a misapplication of the statute. The trial court did not say that the statute has a presumption of equal time sharing, nor does anything in this vast record, in this case, indicate that the trial court was operating under the assumption that there was a statutory presumption of equal time sharing. And I would point out to the court that in fact, the law does promote ample contact with both parties. Pursuant to 61.13(2)(c)(1), the statute states it's a public policy of the state of Florida that each minor child has frequent and continuing contact with both parents after they separate. While that's certainly not a presumption, it is a public policy of Florida that they have frequent and continuing contact. At most, that comment by the judge was harmless error. And as I said in my brief, dicta by the trial court does not eradicate its reliance on substantial competent evidence to support its conclusions. Excuse me. Nowhere in the final judgment does the trial judge state, or in the record, does the trial judge state that the statute contains a presumption of equal time sharing or anything of the like. What the judge did was a comprehensive analysis of the factors in this matter, and the factors, and she got to the best interest of the children, of the triplets, by finding the best interest of the children implied by the factors. I would point with regards to the standard of review, I would point the court to the Schweiderman v. Schweiderman case found at 114 Southern 3rd, 984. And that's a 2012 case from the 5th District. And there's sort of a similar circumstance in this case, as I discussed in my brief. Basically, the trial judge made some comments within the trial, and the wife in this case was arguing that because of these comments, she misapplied the law, and therefore the de novo standard should be used as opposed to the competent substantial evidence standard. In this case, the trial court made several references to the need for equal time sharing or a 50-50 division of time, which the court indicated was a matter of fairness, would best promote the parent-child relationship. The court in this case said that despite those comments made by the trial court, they would review it under a competent substantial evidence standard and agreed with the husband. And they admitted it was a very close case in this matter. And they said, no doubt other judges could have reached a different result, but in totality, we find a lack of competent substantial evidence. We cannot find, a lack of competent substantial evidence to support the determination or that the trial court abused its discretion. With regard to the factors, I want to point out that the stipulated court-appointed parenting evaluator in this matter, Dr. Hanson-Cohen, found 14 of the 20 factors, which essentially equates to 70% of the factors, to be equal in this matter. Dr. Hanson found 1 in favor of the husband and 5 in favor of the wife. But as Judge LaRose said, if you do a qualitative versus quantitative analysis, you can see that some of her findings were duplicative. For instance, I think Dr. Hanson found factor T and factor D in favor of the wife because the husband lived in a rental versus the wife who owned her home. The trial court found 11 factors weighted equally of the parties. While the trial court did make a finding that she found more factors in favor of the wife, if you actually add them up, that's not true. The trial court found factors B, C, D, E, H, I, K, O, P, Q, and S, totaling 11 to be equally weighted for the parties. 1 factor was in favor of the husband and 7 factors were in favor of the wife. But again, if you do a qualitative analysis of these factors, you'll see, for instance, in factor A, the trial court found the wife's position on overnights was unreasonable. In this factor, the trial court acknowledged both parties' testimony that the other parent prohibited contact with the children during her parenting time. The court found both parties to be inflexible. In factor A, the court ends by saying the court finds the mother to be a little more flexible, but by a small margin. The same with factor F, moral fitness. Wife, after her analysis, the trial court says wife is slightly superior. G, the health, she found in favor of the wife. However, the issue that the wife had that was most concerning to the wife, which was the sleep apnea issue, which was the sleep apnea issue, the trial court found was not an issue due to the testimony of Dr. Conrado in this matter. In factor L, the trial court found both parties are bad at communicating with the other, but wife is slightly better in this regard. Factor T, she did not find in favor of either party. The trial court kind of took factor T as an opportunity to expand on the consequences of their continued inability to co-parent. I'd like to point out that there's no case law out there. There's no magic number in terms of how many statutory factors must be found in a parent's favor in order to justify a parenting schedule. In wife's initial brief, wife relies on the case of JP versus DP. It's 196 Southern 3rd, 1274. It's a first DCA case of 2016. And her reliance on that is misplaced. In that case, they did mention how many factors were found in favor of the mom versus the dad. 12 were equal, 1 was found in favor of mom, 6 were found in favor of dad. However, in that case, it was dad who actually appealed the case. Dad lived in Orlando, mom lived in Tallahassee. So there's no way they could even have a 2-2-3 parenting schedule as they have here because they didn't live in the same city. It's an apples to orange comparison. Dad was actually the one in this case who appealed because the trial court went on to rule that when the child finishes elementary school, then the parenting schedule reverses and the child goes to live with mom. So the number of factors that the court found in this case were just dicta. Similar to the case cited by counsel, the Newman v. Harper case. In that case, one party lived in Florida and the other party, I believe it was the father, lived in Mississippi. So again, it's an apples to oranges comparison in the sense that there's no way the court could have ordered an equal parenting schedule or anything of the like because the parties did not live in the same city. Whereas here, they both live in Naples, Florida. The trial court properly found the parenting schedule was in the children's best interest by evaluating, analyzing, and applying the factors. I'd just like to point out that an analysis and application of the testimony and the evidence under the factors is how the court determines the best interest of the children. And the best interest is made by making findings under the 20 factors set forth in the statute. And in the final judgment, the trial judge even called them the best interest factors. And a case on point of this matter is Neville v. McKibben. It's at 227 Southern 3rd, 1270, 1st District. It's a 2017 case. The father in this matter unsuccessfully challenged the final judgment, arguing because the trial court did not make a specific best interest finding, it did not satisfy the statutory requirement and therefore was error on the face of the judgment. The Neville court disagreed with the father, stating, although the final judgment did not include the magic words, best interest of the child, a plain reading confirms the trial court tracked the factors of section 6113 in its determination of time sharing and the address for school designation. As competent substantial evidence exists to support the trial court's award of 50-50 time sharing, it must be affirmed on appeal. Another case to cite to this issue is Nunes v. Nunes. That's found at 112 Southern 3rd, 696. And that's a 4th DCA case of 2013. This is a little different because it's a motion for contempt. But the mother in this case argued that because the language in the statute says makeup time sharing shall be scheduled consistent with the best interest of the child, the mother argued that the order of the court was fatally flawed because it did not say the best interest of the child. And the Nunes court disagreed with her and said that the order is not deficient on its face because it does not use the words best interest of the child. As support of her, the mother cites to the case of Cobo v. Serralta as support for this issue, and that's found at 13 Southern 3rd, 493, and that's a 3rd District case from 2009. The initial brief cites this case. And that case, the Cobo case, is distinguishable because the mother was deported to Venezuela and the custody of the minor daughter was awarded to the father by the trial court. And this occurred without any findings within the order, without explanation in the judgment otherwise. And the Cobo court noted, while the statute 61.13.3 does not mandate written findings justifying a custody award, the record must at least demonstrate that the factors were considered in making this award. Clearly, the factors were considered and more than considered in making this final judgment in this matter. There are comprehensive findings, as I previously pointed out. To Judge Lucas's point regarding the hired witness, the hired expert witness for reviewing the report, Dr. Hansen's report, the trial court did allow Dr. Day to testify to aspects of Dr. Hansen's report, including the methodology, fact gathering, alternative research, literature, strengths and weaknesses of the data collected. What the trial court did not allow her to testify to was to give a specific recommendation on her own parenting plan. I think the parenting plan should be X. One, that violates the rules of evidence. There was no foundation for her to do so. And two, that would violate the standard of care for a parenting evaluation. And again, I pointed out that there was no request for a psychological testing, which is one of the main critiques of wife's hired expert. Dr. Hansen testified that there were two schools of thought. One.
And Ms. DeVries, just to let you know, you're approaching your 20 minutes.
Okay, thank you. And I just quickly cite to the case of Oldman v. Green, 263 Southern 3rd, 807. And it's a Florida first DCA case, 2018, holding that you have to make a request for psychological testing. Clearly in this matter, the wife knew that Dr. Hansen was not going to do psychological testing. This was a 6-month process. She could have requested it at any time and didn't. The final judgment is supported by competent and substantial evidence. And just to quickly touch on the shared parental responsibility.
Actually, Ms. DeVries, you're right up your 20 minutes, man.
Okay.
So.
Thank you.
All right, thank you. Okay, and if I could have you mute your microphone, Ms. DeVries, and then Ms. Perry, I'm looking at the clock. You have 3 minutes for rebuttal, okay? And then if you could unmute your microphone so we could hear you. Excellent.
Okay, Your Honor. First, I'd like to apologize. I thought for sure that psychological testing was requested, so I apologize. I'm sure Jennifer knows this case better than me since she was than I do, since she was at the trial level. So I apologize for that mix up. I'd like to read the court's findings under subsection T. It says the court wants to note that parenting time is not an award. It is not something the court uses to punish a parent. As stated above, the court finds the mother's testimony to be more credible. The court thinks the father has a problem with telling the truth, but how does that affect parenting time? The court is not going to punish him by punishing the children. The children need to be with the father, their father. This is what's important. The statute presumes that the children should spend as much time as possible with each parent. Right there, that is a presumption of 50-50 custody, that the children should spend as much time with each parent. That means let's split it equally each time with each parent. Then it goes on to say, one thing that factor affects is the father's ability to communicate, but if enough specifics are put in place, those issues could perhaps be addressed.
Ms. Perry, the part that you just read at the beginning that you said right there, that's literally a direct quotation from what the statute says, though. All the court was doing was parroting what the statute says.
No, the statute says that the statute does not say that. The statute says, the statute
Part,
promotes.
it says that there's a goal that each child spend as much time as possible with each parent. That's in the statute.
Oh my God. No, it says it expresses a public policy of frequent and continuing contact with both parents. That's different. That is much different. The statute says it's Florida's express public policy of frequent and continuing contact with both parents following a divorce. That's what it says. It doesn't say equal or whatever she says. Presumes as much time possible with each parent. So this and the axe murderer contact and the fact that all these factors weighed in favor. But let me go on to the next thing, which is giving this ultimate decision-making authority on these extracurricular activities, because there is no way that that is in the children's best interest for the next 15 years for this angry man who, what the court-appointed expert witness testified, that he would use it as a tool to basically torture the mother for the next 15 years. And that could not be in the children's best interest. And the court did not make the requisite finding that it was in the children's best interest, what the statute requires.
Ms. Perry, my timer just went out.
Okay, thank you, Your Honors.
All right, so thank you both. Thank you.